Hi there, I'm Neil Gordon. Thanks so much for staying up with us. Welcome to Law Call, where we've got the answers to your legal questions. Now, here's what's on the docket tonight. In our caller segment, we're going to take your questions about the myths about trial attorneys, what they do, and how they can help you as well. Please give us a call right now. The phone number 803-442-4551. Later on in the program, we are actually going to have our legal brief, and we'll let you know all the up-to-date attorney news. But first, Attorney Vic Hawk is here to take a look at one of your email questions. And good Sunday night, Monday morning.
Yeah, I'm happy to be here. Yeah, I'm happy the viewers are staying up and watching. This is a hot topic for us.
They're troopers.
Yeah.
We're not going to charge them tonight because they've waited up. We appreciate it. And our email question is very interesting. Affects all of us because we all, of course, drive. And this question is from Derek. And now Derek's brother, Vic, actually borrowed his car. He didn't get permission. And then, of course, he had an accident. Now, there is insurance on the cars, but not on Derek's. And so he wanted to know who would have to pay for this wreck.
Derek, the answer to the question is pretty simple. In cases like this, if you've let your brother borrow the car before, it'd be difficult to say that you were going to deny him the use of the car on this occasion. If that's the case, then your insurance would be primary and the parent's insurance would be secondary. However, if he had never borrowed the car and he obviously took it without permission and had been instructed not to, then the coverage that he has under his parents' insurance would cover this accident.
Okay, we'll appreciate the information. Now, for more, you can always visit Vic's website, which is vichawklaw.com, or you can go right here to WRDW.com, and there's an opportunity for you to ask some questions that may come up on an upcoming program. There's a red banner, if you will. You can click on that and let us know what is on your mind. Well, we want to get right to our topic, near and dear to Vic's heart, who is he's a trial attorney. He don't settle is the slogan. You're a trial attorney, and unfortunately, folks in your profession at times take a bad rap. But I think there's a lot of myths, misconceptions you want to clear up tonight.
Absolutely. Trial lawyers are special people. You know, when we have a brand that says don't settle, and we tell our viewers and we tell our clients, we don't want you to settle for a lawyer who can't go to court for you. In other words, a lawyer that's not going to be able to present your case to a jury with the insurance company knowing that they have that risk. You need to be with a trial lawyer who the insurance company knows that they'll have to pay the full value of the claim, and your claim won't be wholesaled. But more importantly, I want you to understand that with regard to trial lawyers, we help people every day, and we help set the standards of the community through our work. Like, say, for example, during the Industrial Revolution, employers used to have employees get severely injured, paralyzed on the job, and they would just tell them, well, you can't work anymore, sorry about your medical bills, sorry about your lost wages. And until trial lawyers stepped up for those families and started challenging employers and filing claims against them, the employers weren't interested in any workers' comp system to protect them. You know, just something as simple today on construction sites. Do you know how many people were maimed or killed as a result of injuries on construction sites because heavy equipment was running all around the site, and every time they would back up, the worker wouldn't have any idea they were backing toward them. And now you hear bells on construction sites all the time. It didn't cost that much for a bell, but it took trial lawyers to force companies to recognize the unreasonable risk of an avoidable accident. And look at tractor trailers now. Tractor trailers have these reflectors all around because of trial lawyers. And I brought on a good young trial lawyer to work with you tonight. And that's Reed Sanders. Reed works in our office. He's not only a good friend, he cares about the people in our office, and he cares about each individual case. Reed, can you tell our viewers about some of the myths concerning trial lawyers and tell them what the truth is, really?
Sure. I think one of the myths to start off is that personal injury claims are skyrocketing. and that these fees and the cost of these personal injury claims are just outlandish, and that's just not true. Personal injury claims actually represent less than 5% of all litigation. Another one is that legal reform is not necessary to protect small business. That's just untrue. Large businesses and really insurance companies are setting that propaganda out to try to make it where small businesses are being hurt by trial lawyers, and that's just not true. A third thing is that trial lawyers do not charge outrageous fees for representing injured clients. Trial attorneys on personal injury claims get what's called a contingent fee, and basically that's a percentage of any kind of settlement or jury trial or award that would be awarded to that client. The fourth thing would be that insurance companies have not raised their premiums based on lawsuits. In 2004, the insurance companies reported profits of $38.7 billion, and this was right before tort reform. 3 years after tort reform, they had a $61.9 billion profit. So obviously their premiums are going up, so they're making money. And lastly, trial lawyers force corporations and insurers to follow the law just like everyone else.
Wow.
Nothing wrong with that.
That's right.
Nothing wrong with that at all.
Glad you could clear up some of that information. That's pretty strong. We have our first caller of the evening. Christopher from Augusta joins us. Hello, Christopher. How are you?
I'm doing fine, sir.
Super. What question do you have for Vic or Reed?
Okay, how you doing, Mr. Vic?
Doing great. How about you, Christopher?
I'm familiar with your name, so I'll ask you the question.
Sure.
Okay, say for instance, me and you, we're in the house together. Yeah, see where I'm coming from?
Yeah, you got a lot of interference now. Turn your TV down if you have that on.
Yes, sir. Okay, say for instance, it's me and you in the house together.
Uh-huh.
It's your charge. I'm not going to say what the charge is, but it's your charge.
Yeah.
But they both of us charged with the same charge.
Yeah.
You plead guilty to the charge, but still have me charged with the charge too.
Yeah. All right, I can answer that, Christopher.
Okay.
Christopher, we see that every day in our work. I mean, this is a common thing in criminal litigation, and probably it's a situation where there's been a drug charge, where the police come in and execute a search warrant, and they just arrest everybody in there. Or there's a traffic stop, and say someone's ran a red light, and they end up searching the car, and they just arrest everyone in there. Now, a good trial lawyer is going to be able to demonstrate whose drugs are whose. And if you're innocent, we'll be able to prove that. There are a lot of different ways that you do that, sometimes arising from the individual case itself, as to the location of the drugs, whether there are prints on the containers, other witnesses, other circumstances that help show who is responsible. But we do that every day, and you can do it if you're innocent.
And if one person has drugs in the car and there's several other people in the car, it's not just that one person that might get cuffed. Is that right?
I think they'll arrest them all, which is why we tell our kids, you better know who you're riding with, and you better know who you're going to see.
Sure.
And because when the police come through, the net is cast wide.
That's right.
Yeah.
Well, of course, we're in a huge medical community, and sometimes malpractice comes into play. That's the focus of Robert's question from Augusta. Hello, Robert.
How are you doing?
Oh, doing just fine. What would you like to know tonight?
I wanted to ask information about, like, if you had a criminal case and they gave you a appointed lawyer, and the lawyer was a medical malpractice lawyer, was that the proper lawyer to settle that case for you?
Well, it can be. It depends on what kind of case it is, really. If you're talking about a murder trial, then probably not. If it was a smaller misdemeanor case or even a smaller felony case, then it probably is okay to do that. As long as that attorney's passed the bar and is able to practice in the state where the charge arose, it's probably okay. Now, you could have an appeal of ineffective assistance on your hand, but as far as the attorney being appointed, I think that'd be fair.
Yeah. Okay. And nothing against appointed attorneys, but they're kind of overwhelmed, right?
Well, especially in the public defender's office. Now, sometimes, like in the private bar on the federal side, they appoint private attorneys to represent criminal defendants, and that's commonly done in the Southern District. And they're moving more toward a list to focus on those lawyers that principally practice criminal litigation, for the reasons that he's just talking about.
And to go off on that too a little bit, just because he's an attorney that practices medical malpractice, he very well may do criminal law as well, just like we do civil work and criminal work.
That's right. And if he does medical malpractice, he's probably a pretty sharp lawyer.
Yeah, that's true. That's right.
That's complicated.
That's very complicated.
Question about it. Well, we're going to continue our chat about trial attorneys. If you have some questions related to the law, we invite you to call at 803-442-4551. Stick around. You're watching News 12 Law Call.
Call with award-winning broadcaster Neil Gordon. And from the Vic Hawk Law Group, Augusta attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. And his chosen legal associates, trial lawyers Melissa Detchmendy and Reed Sanders. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
And more from Vic and Reed in a moment on trial attorneys. First, though, if your lawsuit's headed to court, you had better be prepared to wait a while for a verdict. Personal injury attorney Melissa Detchmendy explains why in tonight's legal brief.
Many people get frustrated after their personal injury lawsuit is filed because such a long time passes before any settlement or trial. Here's what's happening. In the discovery phase, you and your lawyer will need to gather up all of the medical records, your bills, and other proof of your injuries. Some of these must be obtained in a specific way to make them admissible at trial. This just takes time. The other party's lawyers may slow things down by scheduling what seems like an endless number of motions and hearings on motions. They're hoping you'll get tired of waiting and agree to settle for less. If your case doesn't settle, it will go to trial. But trials are on the court schedule, not the lawyer schedule. Having a case that's 2 to 3 years old before going to trial isn't unusual. But if you really have a valid claim, your patience can pay off. That's your legal brief for tonight. I'm personal injury attorney Melissa Detchmendy of the Vic Hawk Law Firm. Back to you.
And Reed, I'm guessing that there's a lot of extra time spent as well on lawsuits that maybe don't have a whole lot of merit. I guess you'd call them frivolous lawsuits.
Well, we don't really spend any time on frivolous lawsuits. At least we try not to.
Right.
And the reason for that is as I discussed a little bit earlier, when you take a personal injury case or something like that, it's on a contingent basis. So how the attorney would get paid is through a percentage of what is awarded through either a settlement or a jury verdict. If it's a frivolous lawsuit, or if it's a lawsuit that doesn't hold any merit, an attorney's not going to want that case, because they're going to have to spend their time and their money to get that case to the courts and through summary judgment hearings and all kind of stuff. And if it's a frivolous case and you know it's not going to win, you don't want to spend your time and money and know that you're not going to get anything in return. So the argument about frivolous lawsuits to me really doesn't hold much water, because no attorney in the right mind is going to just be burning money just to have a case.
If 10 people call your office tomorrow and want to go to court, how many of them would have merit and how many would be frivolous?
Well, I wouldn't say that any of them are frivolous if someone feels like they've been injured. But then, if you look at the facts, and then after you look at the facts and apply the law, you find that they're not entitled to assert the claim, you would tell them. And if you have that, you certainly don't pursue it. And you giving clients that kind of information, really, for the most part, time and time again, they're saying, thank you very much. I'm glad. I thought I had a claim, but I don't. And I'm glad you told me. I haven't wasted my time. And you certainly don't waste the court's time. And we don't file those type of claims because we have families to raise ourselves, and it's economic suicide for lawyers to file claims they're never going to get any compensation for.
I think one of the main areas you see that is in slip and fall work, which I do a lot in. And you know, a lot of people just don't know there's so many technical rules in slip and fall work where the hazards have to, you know, be there and they have to not check on the hazard and all that. Where somebody may have gotten injured at a store, there may not be liability there, and that would be frivolous. So that's the kind of case that we would tell them there's no way to recover on that.
And Reed is an expert sorting through those rules because they're very technical. And a slip and fall case is not an easy case, even though people are badly injured as a result of avoidable accidents.
And we're going to talk a little bit more about medical malpractice. Don from Aiken joins us. Hello, Don.
Gentlemen, how you doing?
Oh, just
great.
fine. First of all, our condolences. We understand your mom passed away a couple of years ago.
That's correct. Actually, on my birthday, December 8th, she was living down here in North Augusta for a while, and when she got MS, she moved up to North Carolina with my sister, and then they had discovered that she had cancer. And she went through the surgery just fine. She had half of her lung removed, but it was the recovery that's the issue here. And like I said, you know, we know it's malpractice, but we're not lawyers.
Did you have Did she have the surgery in North Carolina?
Yes, she did.
Okay. Don, you know, I'm a Georgia lawyer. We have a lot of close friends that are South Carolina lawyers. You have got to go to the state where the malpractice occurred to file the claim. And you can go on the internet and search for lawyers who specialize in medical malpractice and give them a call. In Georgia, it's general rule, it's 2 years. In South Carolina, I believe the general rule is 3 years, but you need to consult a South Carolina trial lawyer concerning that. But in North Carolina, you need to consult the North Carolina trial lawyer because it's different from state to state. In Tennessee, it's 1 year. So I'm sorry I can't give you a more direct answer than that, but I'm telling you to follow up with a North Carolina trial lawyer right away if it's already been 2 years.
And make sure you get as much medical records as you can, because that attorney, that's what he's going to want to see.
Yeah.
And before we go to the break, what's the trigger to whether someone would be able to prove against a doctor medical malpractice? What's the critical legal point?
You have to be able to establish a standard of care, and you have to have all the medical records and have them reviewed by a physician of his peers, and then determine that there's been a breach of the standard of care, and it's different for every case.
Okay, well, if you'd like to get involved in the conversation, the number again, 803-442-4551. Thanks for staying up with us. We've got more of News 12 Law Call. Well, just allow Vic and Reed 6 or 7 hours of shut-eye. They'll be in the morning. They will take your calls if you'd like to chat with them off air. 706-722-3500 is the number. They have 4 offices to serve the community. And online, it's VicHawkLaw.com. We still will take your calls the remainder of the program at 803-442-4551. And we want to get to one from South Carolina. Tony joins us from Aiken. And hello, Tony. Can you hear us? Well, let's paraphrase Tony's question.
Sure.
I guess he wanted to know, Vic and Reed, if trial lawyers are able to take on federal cases, or do lawyers such as yourself just remain in, Richmond County, Burke County, and so forth?
Right. Yeah, I mean, trial lawyers take on any type of case. Federal cases are really no different than a state case. So there's some different procedural rules, and the rules of evidence can be a little different. But for the most part, it's really no different than, if we're talking a criminal case, then it being charged in the state of Georgia versus being charged federally. So to answer that question, yes, we take on federal cases, state cases, whatever.
Yeah, and you have to remember that under federal law, it encompasses the whole United States. So if you have a trial lawyer that's licensed in Georgia, I can go to Tennessee and try a case, or I can go to Hawaii, I can go to Guam, I can go to Puerto Rico. The only procedural thing that we have to do is apply to that local court for them to confirm that we're in good standing here in our local federal court, and and they regularly grant us permission to appear. And it's nothing unusual about it at all. And the rules are the same as a general rule throughout the United States in the federal courts.
And there's certain situations, there's a couple of cases that we have now that started in state court, and the defendants actually removed it to a federal court. So it can kind of get some gamemanship in there with it as well, but it's not unusual for a case to start in one court and end up in another one.
Yeah.
Well, of course, some attorneys, I guess, depending upon what it is, maybe business law or divorce law, maybe $100, $200 an hour. But there are other cases in which contingency fees come into play.
Absolutely.
And why does that occur?
Well, one of the things that Reed talked about at the very beginning of the show was the myth about trial lawyers charging outrageous fees, and the community's saying, well, the lawyer shouldn't have received $100,000, or the lawyer shouldn't have received even $1 million in an individual case. But you have to realize it depends on the amount of work that you did. If you're a silk fence builder and you build just 100 yards of silk fence, you don't get paid as much as you do if you build 5 miles of silk fence. And it depends on the individual case. And we do a contingent fee arrangement, which says that we don't get paid unless we're successful in helping you and we're able to get you the compensation that you deserve. And it's the great equalizer in our society. The poor and the middle class, working class in our society has better access to the court than any other court system in the world. And it's because of the contingent fee system.
An example of that would be, when banks charge those little hidden fees, and there's no excuse for them to charge those. Yeah. An individual can't just go pay an attorney to fight that. It's just not worth it for them, and it'll cost them an arm and a leg. But if you have it on a contingency fee, they're not charging anything up front, and it can put a stop to the abusive nature of the banks or whoever's doing it.
Because the banks might be charging millions of people $5 extra a month that they shouldn't charge. But they will get away with it unless a trial lawyer makes them comply with the law.
Jackie, we're not able to get to your call, but Reed or Vic would be happy to call you back after the program. We thank you all for tuning in. It's late, but we appreciate it. Next week, auto accident claim.
Thank y'all for calling.